The Virginia Tech massacre, and the parents from all over the country were calling the school to find out if their child was dead or alive. What did the school tell them?
They wouldn't tell them. They told them to get HIPAA laws, they wouldn't tell them anything.
They wouldn't tell them anything. Say that loud.
The HIPAA laws, they won't tell you a
The
thing.
HIPAA laws, they wouldn't tell them nothing. These 18-year-olds that we think of as 2-year-olds and that are adults by law. And unless there's a power of attorney on record at the school, school isn't going to give any information to the parents. So when my son turned 18, he's 25 now, when my son turned 18, I stuck in front of him, amongst other things, for the power of attorney, a health care, and a living will. And now he's in Massachusetts, and I'm going to contact the Massachusetts attorney, and we're going to get them updated because it's very important. You never know when you'll need those documents. So those are critically important for any adult of any age. But they are most important for somebody who has been early diagnosed with Alzheimer's, because they are going to lose the capacity to make decisions at some point. And unless they convey to their family, to the lawyer, to whoever, to their doctor, what their wishes are in a clear, concise way, they're not going to have their wishes honored. And that would be a shame, because even though 70-something% of people say they want to die at home, only like 20-something% do. And I don't know the exact numbers, but it's a huge disparity. And that's really a shame. So we try to avoid having people come into my office and say, well, my husband's in late stages of Alzheimer's and now do a power of attorney. Can't do it. And they go, well, I didn't know anything before now. Now I'm in a crisis. Well, crises are not times to plan. And the time to plan is before there's a crisis. So we encourage our clients, and as soon as there's any kind of diagnosis, come in, do them, and then we'll update them every couple of years until the person can't do it anymore, so we have the latest and greatest.
Excuse me, why couldn't you do a power of attorney on him? He just is too confused, he couldn't sign
You
papers?
can't ask someone who doesn't understand the nature of what he's signing to give somebody the power to make decisions for them.
So who would make the power then?
Well, there'd have to be a guardianship done.
Okay. And who would decide that? The family?
Courts.
Court, okay. So you're better
Court.
off doing it.
You don't have these documents, the courts decide. Who wants to do that?
Somebody.
Nobody. Zero, nobody. So that's why these are so important. Anybody can end up in a guardianship proceeding in court. I mean, there are attorneys and guardians that make a living doing guardianship. And I would tell you that this situation we've just talked about would be a real shame, because guardianship should be reserved for issues where, like, the kids hate each other and somebody's been stealing something, or situations, the exception, not the rule. And so anybody with dementia obviously should have a living will. Clearly, you have to have capacity to do a living will and the other advanced directives. Capacity is sometimes in the eyes of the beholder. It doesn't necessarily mean that they get a 30 on the mini mental. I got a 29.5. You want to know how I got a 29.5 on the mini mental? You all know what the mini mental is? Yeah, most of you do. I was subtracting my 7s, and I misspoke. And I subtracted, and I hit the wrong number, but then I subtracted again and hit the right number. Like, I subtracted 6 and then 8 because I only said the wrong number. So the doctor said it was a 30, but I consider it a 29.5. So even if the person doesn't score well on a mini mental, my mother would not score well on a mini mental. She's got some brain atrophy. She would certainly not pass it. She certainly has enough cognitive ability to say who she would want to make decisions for her if she was incapacitated. She knows who her family is, absolutely. She knows she's about to have her first great-grandson, like, as we speak. That's why my phone is on here. She knows all of that. She just wouldn't be able to have quite that short-term memory to pass the mini mental. So it's not a question of what a physician might say in terms of capacity, because their definition of capacity is different than the legal definition of capacity. And the legal definition of capacity would be similar to the capacity you need to make a contract. But you have to understand the nature of what you're doing, the nature of your assets, and a basic understanding of the ramifications of the document. So often having a doctor's report saying the person's incapacitated that's a medical determination. It's not necessarily a legal determination. And people have spurts of capacity and incapacity. I will often talk to people who are doing powers of attorney for, and if they're kind of on the cusp, I'll say, which is the best time of the day? When are they most lucid? So that I can ask them the right questions and see if they're competent enough to do the documents. But, we're not going to do that, at 4 or 5 o'clock in the evening, because none of us is lucid at 4 or 5 o'clock in the evening. So certainly our Alzheimer's patients are sundowning or whatever. We're not going to do while they're in the emergency room or in the hospital, because we know that that's just going to add to their lack of capacity. We're going to want to do this when they're home in the morning or whatever their best time is. So capacity is a very, very important issue. And again, the judgment of capacity is almost always made by the attorney preparing the document. And that's important too, because I'm going to note in my file that the person understood it. So if there's any contests or any arguments down the line, it can be resolved then, and it's going to be in my notes who the person wanted to. I mentioned to you POST before, Physician Order of Life-Sustaining Treatment, and I think did we put that in the packet?
Yes.
Yes, I thought so, okay. That's your packet for information only. That doesn't exist really in the state of Florida, but that doesn't mean we can't learn from it. It's a hot pink form. It's on that color.
It does exist elsewhere?
It exists in many places, many states, but this is Florida, so don't hold your breath for it to be here anytime soon. Yes, it's in many states. It's in New York, it's in Oregon, Michigan, a couple of other states. It's called MOST in New York, Medical Order of Life-Sustaining Treatment. So if you would Google it, you could Google POST or MOST and you'd see which states are in it. It's on a pink form because that's how we designate it, and we know that it's again kind of like the DNR is on a yellow form. So this is a medical form, and the reason it's important that someday we have these is because this gives the physician and the patient an opportunity to do the advance directive with the input of the doctor. The way Dr. Hoff and I were talking about it last year is like the lawyers speak French and the doctor speaks Spanish, like Venus and Mars. There's no right or wrong, it's just we speak a different language. So when they look at a living will, that's written in the legal terms from the statute. That's not how doctors think, and lawyers don't think how doctors, and vice versa. So hopefully at some point we'll have this, but you can use this as a guide to enhance the living will of your clients by, or your patients, by asking them all of these questions and documenting it so that when the person is incapacitated, they will have already taken the burden off of the family. Everybody has a right to designate someone to make healthcare decisions for them in all 50 states. But once in a while there will be a renegade court case that will say if the person doesn't do a document, then they can't have some other family member make decisions for them. Those are usually renegade cases, but they happen often enough where we really don't want to even begin to take those chances. One of the places that we see some issues with end of life and dementia are in nursing facilities, because nursing facilities have like more regulations than I don't know what, and they're there to protect the public. But if somebody is malnourished in a nursing home, the nursing home can be cited for that, and yet you may not want to be feeding an end-of-life patient, so they may need to bring in hospice or something. But there are issues with that because there's a lot of constraints. So if you're working with a patient or a client or a family member in a nursing home, all the more reason to consult hospice, bring them in, because the nursing home is going to want to treat. The nursing home is going to want to make this person better. That's what they're mandated to do. And they were mandated to do this 50 years ago when we didn't have any of this stuff. But the rules haven't changed over the years in terms of what they have to do. I do want to give you the end of the story of the physician whose father-in-law died. Her father-in-law was on hospice, and The goal of hospice, as you know, is to assure patients that their autonomy is respected, as much to alleviate the pain of the family as to the burden of the patient. And so they had Dad on hospice at the end. I'm a great believer in hospice, as you can see by the guests we have here. And she says this, and I'm just going to read it. I was with my father-in-law on the last day of his life. He sat in bed, face so luminous that the sunlight seemed to reflect off his cheeks. It was hard for me to take my eyes off him that morning because he looked not like the man I'd always known, but the man I'd only seen in pictures. He looked as he had in the full bloom of his youth, gentle, beautiful, and eyes shining with hope. Later that day, I understood why. My father-in-law was at home. He was surrounded by family, and he was dying as he wished. He, one of the winners, had won. So I will leave you with that thought. I will tell you that our office is committed to working with and serving the Alzheimer's community. We have resources. We have invested emotionally, financially, and in every other way into resources to give people information on Alzheimer's disease. If you go on to www.southfloridamemorylawyer.com, you can sign yourself up and anybody in your network or friends to get a whole host of good information.